Looking at the conference program, I can see that one of your biggest dilemmas over the next 2 days will be deciding which workshops to attend. They cover issues ranging from understanding the needs of victims, supporting victims of sexual assault, domestic violence and victims of human trafficking, and responding to the needs of the vulnerable victims of crime within the criminal justice system. But I don't think you mind me suggesting that even with 50 sessions, the conference might not cover all the issues affecting victims of crime. I hope that service providers at this conference will be challenged by the presentations and find the information useful in improving their services. It's also my hope that researchers will be encouraged to expand their work in this field. I've made a note of the sessions on victim impact statements to be held this afternoon. The topic of for Tracy Booth from the University of Technology in Sydney is the voice of the crime victim in the sentencing hearing, an improperly enacted and damaging ritual. And Sarah Krasnostein from the University of Melbourne is conducting a session, A Right to Know. To what extent are sentences affected by victims' impact statements? Good question, that. They recognise that victims now have a voice in the administration of justice. After all, it's only proper that the law should not only assess the effect of a crime on society, but also the personal impact on those who are left behind to pick up the pieces. What is important is that all involved in the justice system treat victims with sensitivity and respect for their grief. And what is behind that's what's behind, and it's a controversial policy, the O'Farrell government's plan to amend sentencing laws to allow judges to take into account, in some cases, as an aggravating circumstance, the actual impact on the family victims of homicide. Now, whether this be done by just the evidence in the case or other evidence, or requiring cross-examination of the victims, family victims, on their impact statements is another question. It's very difficult to add to a sentence unless the evidence is tested in a proper way. But there are cases where victims, family victims, have actually witnessed the death of their loved one, sometimes felt that they caused that death, where the government feels, as followed in some other states, that sometimes that should be an aggravating circumstance, despite the traditional attitude of the law that all lives have the same value. The O'Farrell government believes a judge would have to consider the possible and probable consequences of criminal behaviour, not only its significance to society in general, but the actual effect of a specific crime upon those who have been intimately affected by it. The O'Farrell government believes it's another step towards restoring public faith in the fairness of the criminal justice system in New South Wales. And I think you'll be hearing a very learned discussion by former Justice David Levine on victims of crime and the way sentencing proceeds. He has had an enormous amount of experience in that area, and you'll learn much from that. I congratulate Victim Services and the Australian Institute of Criminology in organising this conference, and I assure you that I'll take a great interest in the research and ideas discussed at today's proceedings. I think that's all I wish to say, but I declare the conference open and ask you to enjoy it. Thank you.